Estamos en el segundo Foro Internacional La Innovación en la Justicia, organizado por México Evalúa y la Fundación Friedrich Naumann para la Libertad. Les invitamos a interactuar a través del sitio de internet oficial del foro, innovacionenlajusticia.mexicoevalúa.org, así como a través de las redes sociales oficiales de México Evalúa, en Facebook, Twitter, Instagram y la transmisión a través del canal de YouTube, utilizando el hashtag Innovando la Justicia. Pueden conocer más sobre nuestras y nuestros panelistas en el sitio oficial del foro, innovacionenlajusticia.mexicoevalúa.org. Vamos a continuar con el programa del día de hoy. Tendremos a continuación el panel titulado Justicia de Género, Innovaciones e Impunidad, quien lo va a moderar Fátima López, directora de la Red de Abogadas Violeta en México, y donde participará Liliana Arrieta, directora de País de Abogados y Fronteras en Canadá,
Arrieta from Advocates de Frontières
Reyes,
Canada,
consultora de la Iniciativa de Mujeres para la Justicia de Género
of the Women's Initiative for Gender
de Colombia,
Justice Consultant for
y Rocío
Colombia,
Villanueva Flores, decana de la
and then
Universidad
Rocío
Pontificia Católica de
Villanueva
Perú.
Flores of
En este
the
panel se
Pontifical
abordarán las
Catholic
oportunidades de la
University of
innovación
Peru.
para construir condiciones más igualitarias para las
We are
mujeres y
here to
personas
build
con
more
identidades
equal conditions
feminizadas
for
en la
women,
justicia, así como los retos y avances para la justicia de género que ha habido en los últimos 2 años. Le doy la palabra a Fátima
Now I will give
López,
the floor
directora de la Red de
to
Abogadas
Fatima
Violeta.
Lopez.
Bienvenida.
Welcome. Hello, good afternoon, everyone. For me, it's a pride to be in this panel, being able to moderate with such panelists from many countries, Lilian Arrieta, Michelle Reyes, Rosan. Thank you very much for being with us today, because we are going to be addressing an important topic, gender and justice. As I was getting ready for this presentation and the moderation of this panel, I had the opportunity to go through some documents that I happen to find very important to discuss as the initial part of what we're going to be saying today. And as UN Women, Mamlu Manuka issued this, if you subject yourself to a test of COVID-19 virus, nobody will ask you what you were wearing when you were infected or whether you were drinking alcohol. You are sure that your test will be examined in a lab, and that reasonable likelihood that you will receive healthcare. The response will not depend on you being believed. You will not feel such a level of embarrassment that could impede you from looking for help. You will receive assistance and support, a treatment that we know that does not happen towards women that have suffered any sort of aggressions. For me, it's important to start the panel in this way so we can think about the way in which we can create new ways to have social justice for women and for it not to be any longer privilege. And the figures that we were analyzing before the presentation allowed us to see that all the way up to March 2020, when you can, which is the date to which you can find official, we have 20 million people infected and 2.6 million deaths. During 2019, according to UN Women data, 243 million women and girls suffered sexual violence or physical violence by their partners. So we have seen in several panels that violence, gender violence, is the other pandemic, the shadow pandemic, as it was said. We are living and undergoing in many ways and many forms of violence that have increased in the pandemic and have made justice to become a risky situation for women. In many courts around the country and the world, people were saying that there were different criteria to justify the presidential appearance, but I continue to think that these judicial administrations, do they continue gender cases as being exceptional or urgent? Have they thought about the emergency or the need of a mother so they can help their children? Also, we can help how justice can get in an appropriate way for a divorce case to shorten times under which women we are going and appearing before a jurisdictional entity. We have to wonder about changes in the justice administration that have a gender perspective for the legislation and practices that institutions are currently maintaining. Stop increasing inequalities just by the mere fact of being a woman or a non-binary person. Personally, I think that it's high time that we turn to see the judicial systems and that we started to think again about new possibilities that can really promote access to justice and guarantee human rights, as well as to enforce judicial norms during and after this crisis, because access to justice for some women is a matter of life or death, and this access cannot be outstanding during the pandemic, while we know that we are having outbreaks again all the time. We know that justice for women effectively is a matter of privilege, and we have to think about this again so we can get to go. This event's dynamic will be as follows. Each one of our panelists will start speaking for a short period of time, and they will be sharing their opinions about the questions that we're going to be making for them, so they can tell us what they consider with regards to the topic that we're going to be addressing today, and which is a very important one. That's the reason why now I will give the floor to Lilian Arrieta. And I will make for this question, which will be the same for the next the two panelists. As a result of the COVID-19 pandemic, the inequality the gender inequality gap has been increased. How can innovation help build more equal conditions for women and feminized identity people? Lilian, thank you very much to be with us to share in this panel. Good afternoon, good morning, good evening, depending on from where you're listening to us today. With the digitalization, we can be watching this panel from any part around the world. Thank you very much. Thank you, Mexico Evalua, for the invitation. It's always a pleasure to meet again women that I admire a lot to discuss about these topics that interest us a lot, as can be gender focused justice, because we know that many of the topics, many of the public policies and the exercise of the public function does not affect us in the same way men and women. And for justice to be expeditious and fulfilled as the Salvadorian constitution establishes, it has to be administered with a gender focus, with that differentiating policies, so we can really reach the population groups that need this the most. And as Fatima was saying at the beginning, in fact, I'm going to be speaking about this at the end of my presentation. The shelter pandemic during COVID-19 pandemic, besides disinformation, which is the third pandemic, was the increase of gender violence, right? So I'm going to divide my presentation up into parts. First of all, poverty, digital gap, and gender. And number two, the policy adopted by the judicial entity of El Salvador, so we can try to make justice more accessible. And the third part consists in the actual impact that these innovations may have had that were implemented from the judiciary. So I will start by giving a very similar scenario for women, because in El Salvador, and I'm sure that in many countries in Latin America, poverty has a woman's face. And if we see this from a cross perspective, poverty has a woman's face. who lives in a rural setting and who has a very impoverished work because she is unemployed because of the pandemic, and oftentimes she is the head of her home, in which she is the only parent. And when she has a partner, well, they have a care burden that men do not have. This problem of poverty has a direct relevance on what we're analyzing, because this relates to the access to digitalization, innovation, with access to ITs, which are the entry points to many of innovations that the different judicial entities have tried to implement because of the pandemic that made, in many cases, impossible to have on-site and 100% on-site justice in El Salvador. For instance, the digital gap is greater in a rural setting than in the urban setting. The difference is huge. And when we see this from a cross perspective of women, well, there is a broader digital gap for women, and just like poverty behaves, that's the way in which the digital gap behaves. And there is a bridge in terms of access to internet, and we have even less women in general with access to internet than men. We have different universities studies, international organization studies with their own figures, but all of them have this common denominator. The judiciary in El Salvador tried to implement some measures during the pandemic to make justice more accessible to people. It allowed for lawsuits to be filed via email, while lawsuits in El Salvador, we do not have a digitalized file yet, so everything has to be on site. You have to go with your bunch of copies, and you have to file your lawsuit on a site at the appropriate court or at the lawsuit receiving secretary, or the space where we can file lawsuits and actions. Something that they should try to implement was the possibility by email, but mainly before constitutional justice. And for this, we had to all of us who wanted to file a habeas corpus lawsuit, for instance, because a relative has been detained with all of the extraordinary measures that we have that we had to justify so we could move around during the lockdown. We must have had access to a computer or to a mobile phone. In general, it's a computer, while many aspects have been digitalized regarding the filing of lawsuits. Sometimes it's not about this, about these spaces. What are they called? Interoperational spaces, or which work likewise on different platforms. And I can see this both or as on a computer or on a mobile phone. And here we're having an impossibility for women because the access that they have is mainly through mobile phones and not through a computer. So what if platforms that are intended by the government to administer justice only work for the computer format and not for mobile phone format? We are from the beginning limiting access for women to these benefits that we are looking for through remote access. Likewise, the Judiciary of El Salvador implemented hearings. That's one of the changes that we made, and also we created and we broadened the coverage of the electronic notification system to further users and people. So we had an attempt here to bring together that stage of filing and then hearings, digital hearings. But once again, the implemented mechanisms were rather working better for computer-friendlier formats and not for mobile phones. Now I will Well, I will stop here and I will depend later on in all of this. But I want to tell you that in many spaces in which a woman is the woman is living with a partner and has access to a mobile phone, with access to a mobile network. In cases of gender violence or aggression, the person in charge of the mobile phone is the partner that is the author of this violence. So access becomes nominal and not an actual access, and that's what's missing in El Salvador. We have to measure the impact, the usefulness, the efficacy of the measures that up to now have been adopted to bring justice closer to people, and especially the impact that this has had on women or on people with feminized identities. Thank you very much. Now I will give the floor to the next speaker, Michelle Reyes. Go ahead. Thank you very much. Can you hear me? Thank you very much for the invitation. I'm very happy to be part of this panel, and of course, the fact that we have Dean Reyes Villanueva here. Thank you very much, Reyes, for being here as well, and Lilia Arieta and Fatima too. I would like to start with a reflection about why at the Women's Initiative for Gender Justice that I represent with this project in Colombia. I am not Colombian, but I am leading the project in this country. Why for us thinking about a tool like the principles, the Hague's principles of gender violence is an innovative tool when we were told that about the presentation of the principles and the way that led us in 2019 to the Hague principles on sexual violence. The term of innovation for us to prepare for this presentation represented an opportunity as well as to think about the principles from this perspective. What makes these principles to be an innovation when we think about sexual and gender violence? Sexual and gender based crimes are the most invisible ones, and when survivors, mostly poor women, decide to bring their cases to justice, as we well know, they're facing a series of obstacles of prejudices between among justice apparatus, and also in terms of how to understand sexual violence at first stage, prejudices of how to consider the indices as to consider these acts among many other elements. One of the main challenges has been how to understand sexual violence. What makes a sexual act to be a sexual violence crime? While the departing point for us when we work on the Hague principles of sexual violence was international law and understanding this category of sexual violence as a category within crimes against humanity. Well, we found out that this is a challenge for internal legislations and systems. If you allow me, if you give me 2 minutes just to describe what the Hague principles of sexual violence are for those who haven't had the opportunity yet to get to know this instrument, this tool. The Hague principles of sexual violence were launched in December 2019 in The Hague, and they are the product of a series of a project of over 2 years, together with some research around or with a collection of some of the most important standards of international criminal law. Work was conducted with over 500 survivors in several countries, focusing on have the content on sexual violence based on the experiences and testimonials of these survivors. We started from the realization that there is no generalized vision of what sexual violence means, and a uniform consensus that a sexual act becomes a sexual violence crime, while international law has and internal regulations. I have several dispositions regulating several acts like sexual violence. There is actually no generalized division, as I was saying, of what constitutes sexual violence or damage experienced, and no uniform consensus on this category. We know that when we speak about sexual violence, we usually speak about all violations to integrity, sexual autonomy, and integrity, usually characterized by humiliation and destruction, while there are several forms of sexual violence that have been typified both in the international law and internal legislation. Some do not find a space within the specific criminal types. For instance, forced marriage, genital mutilation, forced sterilization, just to name a few. And the campaign, which is about call it what it is, the quality what it is, the campaign tried to collect these experiences to build the Hague principles for sexual violence. And based on three main sections, we have a statement of the civil society, in international criminal law principles, and principles for those responsible for public policies in terms of sexual violence. And it tries to cover the content of this category based as well on the identification of those things that are part of essential elements for the construction of sexual violence, and how we can understand consent, and how we can analyze some of the indices, what is how we understand the body, what are some of the elements of sexual violence. And now, why is this an innovation for us? From the invitation that we received to think about the Hague Principles as an innovative tool rather than a technological innovation, this is an innovation around the premise and the statement of focusing a sexual violence category as a category, encouraging to and inviting us to a reflection around all types of sexual violence. And based on over 500 survivors, we set forth this vision as an innovative one, taking into account all of the experiences from the different diversities, from the different cultural approaches. And we want this from the international regulation, but also national and domestic legislation to have a content some dispositions around sexual violence. We have this like the statement from, and also in some other regulations, for instance, the Colombian Criminal Code that has a disposition, a very interesting disposition, Article 106 of the Criminal Code, that regulates those sexual acts that do not include body violent access, which can be considered sexual violence. So we have this innovative approach that we consider to be able to bridge the gap of gender inequality, allowing survivors, including women and feminized identities, can have a greater access to justice through a trial, but also for judicial operators to incorporate this broader vision to all forms of sexual violence to open the way up. And in this context, following the statement of the first question, the context of the pandemic, as you know, has exacerbated situations in which these sexual violence acts are committed, and this takes place in a legislative context, which has no specific type in domestic legislation. We can continue reflecting upon this or in the second segment, but having 13 seconds, I will take this opportunity to stop here. Thank you very much. Thank you very much. Now I will give the floor to Dean Rosia Villanueva Flores. Thank you very much. The floor is yours. Thank you very much, Fatima. So I want to thank this invitation and expressing my pleasure to share this panel with Michelle Reyes, my colleague at the law school at the Pontifical Catholic University of Peru. And it's a great pleasure to be with Lilian Arrieta to share once again a panel on gender justice. I would like to speak about in this short presentation in the most succinct possible way the problem that concerns the impartiality and the reasoning of the magistrates when they solve the cases, especially of sexual violence and the gender stereotypes. I think it's very important when we analyze the judicial decisions in this field to bear in mind the relevance of judicial impartiality, which is a principle that explicitly or implicitly protects our Constitution and the American Constitution on human rights. Therefore, I'm going to divide my presentation up in the judicial impartiality and duty, and then corruption and civil cases. So we can speak about corruption, another of the big pandemics, and it's linked to gender violence. I just want to remind you that the magistrates are responsible for being impartial, and that's their duty, a duty of independence faced to the trials parties, and this entails for magistrates not to solve based on prejudices or bias or favoritism. So I was at the Inter-American Court. Impartiality demands the magistrate to approach the cause free of